I'm going to introduce Kieran, Myriam, and Caroline, and then hand over to Myriam because this is her show, and let her take this forward. So if you give me a moment just to pull up my notes. I'll start with Caroline Simson. The name will be familiar to probably everybody here, and we get now to put a face to the name. Caroline is a senior reporter at LAW360 and focusing on international arbitration. She holds a bachelor's degree in English literature from Binghamton University.
Binghamton.
And is an avid traveler. But here at least we get to do it virtually. And she studied abroad at the University of Edinburgh in Scotland, and also spent a semester in Ireland interning for a media company. Next, we got Kiran Nasir-Gore, who's got more than a decade of expertise in public and private international law, foreign investment strategies, and international dispute resolution. Kiran advocates before the US courts, ad hoc arbitration panels, commercial and investment tribunals, and investigative authorities. So really quite a wide range of fora. In addition, she provides strategic advice on treaty law, conflict of laws, and legislative reform. And that's interesting because then it means that you don't not only have the council perspective, but also the policy one, and as we'll see very shortly, the academic one too. She's a counsel in the law offices of Charles H. Camp, working on all facets of international dispute resolution, and amongst other roles, she is an associate editor of the Kluwer Arbitration Blog and a professorial lecturer in law at the George Washington University Law School in the International and Comparative Law program. Last, but certainly not least, we have Myriam Seers. She practiced, so just in terms of locations, I should have asked, but I'm guessing Caroline and Kieran are joining us from the US.
That's right.
That's right.
Myriam is joining us from Canada. She practices litigation and dispute resolution with a particular focus on investor-state arbitration, international commercial arbitration, commercial litigation, involving clients in the mining, electricity, oil and gas, and transportation sectors. She has appeared as counsel before the Supreme Court of Canada, respect, in international arbitrations under the ICSID, UNCITRAL, and ICC rules, in all levels of Ontario and Canadian federal courts, before Ontario administrative tribunals, including Ontario Energy Board and Environmental Review Tribunal, and in domestic arbitrations. In 2019 and 2020, she was recognized by Who's Who Legal as a future leader in arbitration. This biography will not be complete if I didn't also add that Myriam is a regional editor for the Delos Guide to Arbitration Places. Before I complete these introductions, I'll just say a word or two about the GAP. As I'm guessing most of you, if not all of you know, it is a publication designed to assist in-house counsel, corporate lawyers, and arbitration practitioners with efficiently accessing key insights into a large range of jurisdictions. It was nominated for the 2019 Global Arbitration Review Award for Innovation, and we're right now preparing the second edition. And with that, I'll hand over to Myriam. Thank you.
Thank you so much, Hafiz, for the overly generous introduction, but thank you. And again, since we're such a small group, it would be really great if this can turn into a broader discussion. So ideally, Paula and Megan's matters just magically go away and we can all have a discussion. James, hopefully you can participate as well. And if not, well, we'll just talk to each other. That's all good too. So I thought we would start with the issue of whether, either in the context of the pandemic or the growth of other arbitral kind of centers like Mauritius and the BVI and so on, whether that has had any impact in your view on democratizing or increasing the diversity of arbitration in terms of venues or in terms of who the counsel are, and any issues that you care to comment on about the way things are going diversity-wise. Maybe Caroline, would you like to kick us off?
Yeah, I mean, so basically my approach to this was, you know, when I first started covering international arbitration at the beginning of 2016, and, you know, as I was getting my feet wet, you know, learning about what international arbitration was, you know, a topic that kept coming up as I was talking to more and more people was diversity. And it just happened that year that they were having the ICA biennial conference in Mauritius that year, which kind of got me thinking about, you know, more about Africa and about sort of trying to encourage the use of these sort of what I call like alternate arbitral forums, you know. And since then, I feel like the trend has become even more strong. You know, for I forget what year it was, but there was an arbitration center that opened in the British Virgin Islands, I think maybe 2 years ago, 2 or 3 years ago. And there has been a new one opening in Dublin, I believe, that I did a story about. And so I just feel like, you know, we're seeing more and more cities and countries trying to get on, you know, this arbitration train. So, I mean, has it had any effect yet? I mean, it's kind of hard to say. Certainly, especially from the diversity standpoint, you know, when the whatever year that was that they did the pledge, was that 2017? I'm having trouble remembering. But anyway, I mean, certainly that, you know, put a real focus on gender diversity in arbitration. So, I mean, from my perspective, you know, covering things like this, it just seems like as we continue, there's more and more of a focus on improving diversity.
Anything to add to that, Kieran?
Sure. I would start with the idea that I think that what Caroline is also touching upon, but hasn't said directly, is that diversity can be intersectional. So although you do have initiatives like the Pledge, which is focused on gender diversity in particular, I think we all agree that a variety of diversity is really what we're after, because we want the decision makers, the adjudicators, to really be able to be responsive to the parties' concerns. And part of how they're going to achieve that, or part of how they're going to facilitate that, is by having this intersectional diversity of thought approach, you know, that blend that we all love in international arbitration of common law and civil law approaches and other national approaches versus international approaches, and how all of that comes together. So I'll start with saying that I think that what we're trying to achieve is a broad range of diversity, is what we hope to achieve. And part of the reason for that is because the parties are increasingly diverse. I've been practicing now for, I think it's about 12 years, and I've seen increasingly over that time, at least come my way. So being a North American practitioner coming my way, I see more and more Asian parties, African disputes, or ones involving an African party, ones involving the Middle East. And when you put that all together, I'm seeing a lot more diversity among the parties, the disputants. So how do we ensure that their needs are being heard and addressed in an effective way? I think variety of seats, emerging seats and centers, precisely the kinds of thing that I think Delos' GAP, what a great question to start with. The GAP project, I think, is focused on addressing exactly what Caroline is referring to. And I think that absolutely it's a trend, and I think it's a welcome trend because it intersects so nicely with the goals that all of us hope that arbitration can help address, alongside in addition to national court litigation.
Yeah, it does seem to be like a democratization of arbitration, in that it's becoming more and more accessible to, you know, more diverse parties.
And how do you encourage the parties? I think amongst counsel, it is fair to say that there's a big push towards diversity in a lot of its forms. But how do you encourage the actual parties to accept, for example, kind of a newer arbitration institution like Delos, or a less tested seat, or a younger practitioner? I mean, speaking for myself, I'm a younger practitioner who is trying to break into the world of being an arbitrator, and it's not an easy start. So you have diversity in sort of all of those shades. How do you encourage your clients as counsel, or how can parties be encouraged to take a leap of faith and start to look at options that are maybe not so traditional?
I might start with that. I'm not an arbitrator. I don't have an arbitral practice. So I'd be curious to hear what those of you who are arbitrators, I know James, for example, sits as an arbitrator as well. I'm very curious to hear what your views are as from the arbitrator's perspective to get those opportunities. But I can say from the counsel perspective, it frankly depends on who your clients are, and your clients will bring a number of challenges depending on who they are, but the challenges are similar. If you have large institutional clients who have stakeholders, everywhere from their corporate boards to their general counsel, really large disputes, large dollar value at stake, it is very hard to convey to them the need to try someone who is untested, because they do look for that arbitrator bench memo that you put together telling them why you think this person is the person who should solve their dispute. And they then have to take that information and justify it to their board or their general counsel or someone who just simply does not understand arbitration and arbitral practice. So that's one set of challenges. I think if you've got a smaller client, someone who's less comfortable with arbitration or less experienced with it, their challenge is simply, well, they want to use who the big people use, right? They want to use the tried and tested arbitrators that have been successful for companies like the first group I described. So no matter who you're talking to, it is a challenge. I always consider it a win when my client entertains those newer and younger and up and coming names just at the first cut, even if they don't make it to the second cut or the final round of their consideration, because I know it means that they're at least open-minded. But it is hard. I will say on the other side, the arguments that usually help me in conveying the need to have more diversity in arbitrators is frankly that the old boys club of arbitrators is too busy. They're getting older because they've been at this for a long time, so they want to slow down their practices, or they're already full of appointments. And then you have younger people like Myriam and James right here, two great younger people who are focused on their arbitral practice, who have energy and enthusiasm and the drive to really develop their profile. And when you have that to compete with, I mean, nobody can compete with energy and enthusiasm, right? I mean, it's passion, and that is something you want your dispute resolution adjudicators to really be passionate about what they're doing and engaged in it. And sometimes you don't get that from the really overly busy arbitrators who have done it 1,000 times. So I think personally, that is how you get the hook into clients to really open up their minds. But it is a very challenging conversation to have, and it's not always a successful one.
I think you're really onto something with time, actually, because I think the time, it depends on the case, obviously, but in the 3-person panel with 3 very experienced practitioners, the wait times for awards are getting quite unacceptable for a lot of parties. And if you have a situation where most business situations are kind of demanding a more rapid solution depending on the particular circumstances of the case, but that might be an excellent argument for appointing someone who has more time to devote to the case. Anything to add to that, Caroline?
No, but it really is a really interesting point with respect to the time, because, when I've been writing these types of stories, I've always asked people, kind of what's in it for the other parties. And, I never really got like a great answer, other than that, we have to encourage diversity because, there's all these different parties that are using arbitration, and it's going to be better representation. But yeah, I mean, the time and the energy aspect of it is pretty interesting, I think.
I mean, all these statements and arguments and philosophies are great, and I think most reasonable people would agree with them, but there's a seed difference between that and actually convincing your client that because of those reasons they should appoint, Ms. X instead of Mr. Y. Very different thing, right? So I think we still have a long way to go.
That's I think the biggest hurdle, because there doesn't, in principle, I don't think anybody disagrees with there should be more diversity. Exactly. It's just it's a matter of yeah. I mean, it's a matter of making it like a practical thing too.
Yeah, well, exactly. Why don't we switch gears to Caroline, this was one of the issues that you raised, which I think is fascinating. So I will just put the question to you the way you put it to me, which is arbitration is a means of upholding international rule of law. Is arbitration a viable vehicle for doing so when considering disputes like the China-Philippines case and the PCA, in which the award issued in the case has been largely ignored?
Yeah, I mean, this is something that's really bothered me ever since I started covering international arbitration. You know, with a lot of these state-to-state cases, if one of the states doesn't want to cooperate, I mean, there's not a whole heck of a lot that the other state can do. And I mean, this has happened a couple of different times. There's somewhere in Central Europe too, there was some fishing dispute, I think. And they just are completely ignoring the result. And, you know, same with like the Crimean, Ukrainian disputes. I mean, there's, it seems like the tribunals have either already, decided in favor of Ukraine or are going to, and obviously Russia's not going to, pay any attention to that. And I mean, same with respect to the Trump administration and the International Criminal Court, which, I think I mentioned in my little pitch there that, that didn't start with Trump, but, how troubling is that, that the US can just say, no, we're not going to listen to that, and, screw international rule of law, and we do what we want. And what kind of society does that lead to? And I just find it a very troubling prospect. And I don't know if that's just me or if people share that concern. And so, I mean, I've been thinking about the viability of international law, with respect to trying to resolve some of the world's problems. And I mean, I don't know, with the rise of nationalism, it just, and maybe this trend will reverse itself, but it just doesn't seem like a very viable method if the countries don't want to respect it.
Do you think that, at least as far as the United States is concerned, the Biden administration will do a little bit better in that regard?
Well, I mean, that's what everybody seems to hope, but I mean, it's really, time will tell. I mean, with respect to China, they're saying he's going to be just as tough on China as Trump was. So, and will he appoint judges at the WTO? I mean, Obama started that trend, so maybe he won't. I mean, I know a lot of people on the Biden side say that he's going to cooperate more with, try to cooperate more with our allies. But in the current environment, I'm skeptical, like I'm a journalist, I'm always a little skeptical. So I'm just kind of like wait and see attitude.
Kira, and you're also in Washington. What do you think?
I share a lot of Caroline's concerns. I might flip the thought process a little bit though, and focus on the legacy of the Trump administration and the choices that have already been made, the choices we already have to live with. So there's the Paris Accords, there's the USMCA and how that was negotiated and how that relates to TTIP. I think there's also the legacy of not participating in a number of Asian multilateral trade agreements, Asia-facing multilateral trade agreements that have recently been negotiated. So although I think many of us in Washington and many Americans and many people I've spoken to worldwide are hopeful that the Biden administration can take a different approach, I think the reality is that we need to first see what the legacy is of the Trump administration and see how much of that can quote unquote be undone, or how much of it is what we have to live with and navigate afresh. But maybe going full circle and coming back to Caroline and Myriam's idea of the rule of law, the international rule of law, I think we can look back into our history and see how, after in the post-World War II era, when all these international institutions were first agreed to, I think that's precisely the idea that we bought into a system. We bought into the United Nations, later bought into the WTO. When you buy into these systems, you are establishing a modus operandi, I would like to think. So even if certain decisions are not adhered to or followed, well, they exist, and they exist because there was a certain level of buy-in, and they exist on paper. It's kind of like an arbitral award. Maybe you can't enforce it, but it exists on paper, right? You've got it. And it's the same, it's a horrible analogy, but you've got it, right? There's a track record, and it's better than not having a track record. And I like to be optimistic. I think I'm quite pessimistic in terms of what the legacy is that we're dealing with, but I'm optimistic that because so long as these institutions persevere, or at some level, we're only as good as the worst of us, and that there is some opportunity to fix paths and improve the international rule of law, which is, I think, something everybody can be passionate about.
What do you see as in terms of the future of ISDS in new treaties or being removed from existing treaties? It hits close to home for me as a Canadian counsel who acts a lot for American investors under NAFTA against the government of Canada. There's a 3-year expiration date on that, and there's no ISDS between the US and Canada and the new USMCA. Are we going to see more of that? What's your view as to what the future holds for new treaty provisions?
It's a really great question. And I think to answer the scenario that you've described that we're living with in the post-NAFTA era, it's actually, I think, we need to understand better why Canada chose not to engage with the US.
I can tell you, it's one of the most sued countries after Argentina. Look no further than that. True. We don't want this if we're going to have to be the defendant. But that's not what this is about.
So I think once you unwrap that, you can think about what that looks like going forward. But as I said, I like to be an optimist. And I think in this post-COVID world, so we're in the post-NAFTA world, we're in the post-COVID world, we're really in uncharted territory in many ways. And I think in the post-COVID world, there will be this need and interest for more foreign direct investment. And I think along with attracting FDI, you have this parallel ISDS paradigm that I think a lot of institutional players find solace and comfort in. So I think although the current trends are showing us that maybe ISDS is on the way out in treaty negotiation, I think in other ways we might see the trends flip just because we are living in unprecedented times where prior track records mean very little. I mean, if you think of when NAFTA was negotiated more than 25 years ago, it was designed to open up an unprecedentedly large free zone, and it worked, right? So it was very successful in many ways for a long time. It was definitely time to overhaul NAFTA. I think nobody disagrees with that. But if we can think about how NAFTA came into effect, we are similarly in unprecedented waters, and I think we can be optimistic. And I think ISDS is something I'm hopeful about. I think it needs to evolve to match the current times, but I certainly don't think we throw the baby out with the bathwater.
Well put. Caroline?
Yeah, I mean, it's an interesting question, and it's one I really don't know the answer to because, everybody thought that when Trump was elected, everybody thought he was going to be pro-ISDS because of all his, international businesses. And that turned out to very much not be the case. So, I mean, and with Biden, I mean, he hasn't really come out and said anything of substance about it yet. And from the indications are right now that he's not going to be focusing on international matters for at least his first year anyway. So, I mean, this is maybe sort of an academic argument, but as far as, will he support it? I mean, I don't know. I've heard some people say that, yes, he's going to support international businesses. And I've heard some people say that, no, because the trade unions, they don't like it. So, I mean, it's just, I feel like we're kind of going to have to wait and see. As far as the rest of the world, I mean, the EU seems to, they've got the investor court that they're really backing. The UN is, looking at that a little bit more in depth. I mean, is that going to be a viable alternative? I mean, I have to say I'm pretty skeptical about that too, because it hasn't really gotten much traction so far with other countries. So, I mean, the whole idea of ISDS, I mean, certainly in the short term, it's obviously not going anywhere. For the longer term, with more countries starting to get a little bit sour on it, you know, I just don't know. I don't really know the answer to that, you know?
Yeah, at least in terms of what's happened in Canada is in a different situation than a lot of other countries, obviously, but still, it seems these things are often a really great idea in concept. When you sign a treaty and you think, well, it's going to encourage all this foreign investment, and we're going to get all these foreign investors, in our case, the U.S. investors and so on. But then when you actually start to face the claims, it's a day of reckoning that's a lot different than perhaps what the idea was at the beginning. So now that in the wave of claims has arrived after the wave of treaties came earlier on, I wonder what that means for the future. I guess we'll have to wait and see.
Yeah, you know, I mean, it'll be interesting to see, you know, I mean, if there are attempts to perhaps do more substantive changes to the ISDS regime than even what the EU is proposing, you know, and if that might alleviate some of the concerns, you know, just I was reading George Cahill gave a speech a couple of weeks ago, or he did a webinar with respect to damages, and he, at the end of the talk, he was talking about, you know, just kind of redoing the whole thing, going even further than what the commission is proposing. And it's a really interesting idea. I mean, would that help to, you know, ensure that investors would be protected while also helping to alleviate some of the concerns of the states? You know, we'd obviously have to see what would be proposed, but, you know, maybe going even further than what the commission is proposing would be something to think about.
What do you guys think about smaller claims? It doesn't have to be limited to the ISDS context, but it does come to mind. I think the latest figures on the ICSID average cost is north of $10 million per case, which obviously makes, you know, it makes cases smaller than whatever the client's threshold is, but smaller than $60 million uneconomic to pursue, which is shocking by most people's standards. What do you guys think? Is that a problem? Would there be more possibilities for pursuing small claims, especially in ISDS, but also in other contexts in arbitration? And what might those options be?
Well, oh, sorry, go ahead.
James?
Third-party funding is the answer.
Yeah.
This is something we always hear is third-party funding.
Potentially an answer for, yeah, in certain circumstances, for sure.
I think another answer may lie in mediation or some kind of med-arb-med hybrid module that takes into account that we can't take on at the outset, like we as in claimants can't take on at the outset such a high cost threshold, and they need to find other solutions. And I think the reality, I mean, that's the sort of the idealistic visionary view. I think the reality is that we're going to see bifurcation. Everything is going to get chopped up. The cases are going to get chopped up into tiny bits as much as possible in hopes of either speeding them up or resolving them more quickly on some, you know, procedural or other jurisdictional type of manner. And whether that actually lowers the cost or the time spent is to be seen, but it's certainly the hopeful view that I think a lot of parties' clients take.
You know, I've often wondered why mediation in investor state hasn't taken off more, because I mean, it does seem to be a good option, especially for smaller claims. And I wonder if that might start to see more growth now that we had that. I think there was a convention that was passed recently for the enforcement of mediated settlements. So I mean, maybe that might help push it along a little bit, but. Also, I think with, I mean, in terms of costs, we'd have to look at what the majority of these costs are. And I mean, maybe if some of it is travel related, I mean, maybe COVID has kind of helped us to realize that, you know, lawyers don't necessarily have to fly all over the world, you know, to represent their clients, you know, and especially for just like procedural hearings and stuff like that, you know, maybe it's not necessary to fly, you know, to, you know, Singapore at a moment's notice.
For sure. James's solution is third-party funding minus page limits. I think counsel fees is maybe counter to self-interest as counsel, but counsel fees, I think, are a very large percentage of the fees for each case. Travel fees definitely add up as well, but I think by far the largest cost item is counsel fees, which I think has gotten out of control in arbitration. I also practice domestic litigation, and in Canada things seem to be much more streamlined. We have page limits on submissions for court and so on, and the world seems to still turn. So I think, at least from my point of view, more streamlined procedures and kind of caps on the ability to over lawyer a case. Obviously, you want to protect the parties' rights to make their case, but I think there's a way to do that in a more, bearing common sense and efficiency in mind, and perhaps institutions like Delos can Hafiz come in and fill some of that. For the larger cases, it is probably not appropriate, but I'm thinking of the smaller ones, which in this context includes a $20 million case. That's a small case by ISDS standards and international commercial arbitration standards. And, obviously you can't, it doesn't make sense to spend $10 million prosecuting a $10 million case, but so that's an interesting, and online tools. The online hearings definitely help solve the costs or reduce some of the costs too. I think the whole situation that has been foisted upon us is one of the silver linings of it is a forced rethink of basically everything that we do, which can only be beneficial. Okay, so why don't we switch? It's actually a very good time to switch to technology generally. Caroline, where do you think this rethink that has occurred and these tools that have been developed very quickly and embraced and adopted in some respects and not in others, what do you think, where do you think the future lies with respect to the use of technology?
Well, it's an interesting question because the increasing use of technology in arbitration was something that I started thinking about last year, actually, before any of this stuff even happened. And because I was talking to a lawyer over at Quinn Emanuel about perhaps the use of artificial intelligence in international arbitration and what that might look like, and things like blockchain and what that might look like. So, I mean, in terms of increasing technology, I mean, I don't think there's going to be any huge changes in the next, 5 years, but, maybe in the next 10 years, we might start seeing things like searching for I remember talking to someone about what was it we were talking about? It was the jobs that associates usually do, like looking for patterns in cases and opinions that come out. That might be something that could be easily done by a computer or an algorithm. So I mean, just little things like that, I think we're certainly going to be seeing more of. Like in terms of making decisions being issued by artificial intelligence, I don't think that's anywhere close, but I mean, certainly, certainly.
But please elaborate on.
No robo judges.
Yeah, robo judges.
Like, yeah, that sounds like it could lead to cost savings. Tell us more.
Yeah, well, they already do that at places like eBay and stuff. Where
$15.99 for your dispute to be resolved.
Yeah. So, yeah, I mean, stuff like that is definitely very far off. But I mean, in terms of more virtual hearings, I mean, so many lawyers who would never even have considered it before COVID, now they just it's now become second nature to them. And Hafez and I were talking about this back when this whole thing first started, about how you guys at Delos were helping to coordinate that. So I mean, and it's just people are realizing, like, maybe for a big, $100 million merits case at the merits hearing, you might want to be in person for that. But for other stuff, procedural hearings and things like that, it's really not necessary,
Exactly. I think what the situation has done is kind of shown us that it's feasible. It's feasible to do a virtual hearing in $100 million case.
Yeah.
It may not be desirable when we have the option to do it or not to do it, but at that point we can pick and choose what we do virtually and what we don't, which will be in the after period. Hopefully it comes relatively
Seems
soon.
far away.
Dare I talk about the after period? Ideally, we'll have this menu of options that perhaps existed notionally before, but that wasn't practically didn't exist. Ideally, now we can customize bespoke solutions based on the situation. What do you think, Kieran? Have you had much experience with virtual hearings? I'm especially interested in witness hearings because there isn't much debate that argument is perfectly fine to deliver over virtual mechanisms, but cross-examinations, more debate about.
So it's interesting that you say that, Myriam, because where I was going to begin responding on this topic is that I actually have quite a bit of experience with doing depositions over video conference. Over a number of years, simply because you can't really justify traveling to Paris to take a deposition of a witness who you don't know is useful in a New York State Supreme Court litigation, right? And so I've done over the history of my career a variety of domestic court litigation where it might have international dimensions. They always had international dimensions, but they didn't have the same impetus and cost considerations that you could really justify going out and traveling and putting a whole team together. Or it might have been, I had cases where it involved emergency applications. And I had one particular matter that I worked on. It was an emergency application in New York federal court in aid of arbitration. And we were given by the federal judge less than a week to conduct X number of depositions to create an evidentiary record to get the emergency application granted. And the witnesses were all in the Middle East. And we had to depose people in the US, defend our clients in the US at their depositions, go to the Middle East to take depositions. It was infeasible to do this logistically with travel. So I've done a lot of video conferencing depositions, defense and taking, and I will say that works too. It's incredibly hard. I think what helps is having eyes in the room. So maybe if I'm the one taking the deposition, I have someone locally, maybe from my firm's local office, helping, making sure that they're not getting fed answers, that documents are the right documents to be looked at, things like that. So I personally have developed some best practices about how to do that. Now, whether I want all of that to go before an adjudicator, like to have it be before the arbitrators and have it be cross-examination only, and it's where I know every question is a useful and helpful and important question, it's something I cringe about. But I will just say I know that can be done. And I know that is where a lot of arbitration practitioners hesitate. And so I just encourage everybody to be thoughtful and creative. I think the reality is that there's always client pushback on all of this. I think the reason all of us want to travel for hearings, for procedural hearings, is because our clients want us to. Our clients think it's so important, which it is, but they see the importance level at such a level that they're willing to pay for it. And so therefore we must travel for it, at least has been my experience. So I think there's just a lot more to see. How are people's modes of thinking evolving in current times? Are they more open to sessions like this where everybody's virtual and it feels intimate, but it might not be? And is that enough to build credibility and authenticity?
I'd be interested to anyone else who's on the line or on the Zoom call. If any other, James, you unmuted yourself, so perhaps that means you have some experience with this thought.
Well,
I'm reading the questions that we've been missing in the chat box, James.
Oh, I'm so sorry.
No.
I haven't. My apologies.
No. I just had a little anecdote there about limiting word count, and an issue that I had in a recent case was that a party had overrun a word count, and the other side had protested and demanded that the submissions be reduced to the required length. To which the answer was it would take them too long and it would be disproportionately costly. to have to embark on this exercise of making the submission shorter. And then there was argument back on that, and I ended up allowing the overrun, saying that I had to make an order before the number of words expended on the argument about the number of words exceeded the number of words complained about.
Did they quote Mark Twain?
Well,
I would have written a shorter letter, but I didn't have
well,
to.
yes, they should have done. But just picking up the points about how technology is allowing us to be more flexible with the procedure and to have people engage in hearings which might have been not so practical. An interesting issue has been raised recently, which bothers me quite a bit, because I do quite a few documents-only arbitrations where the rules don't envisage any kind of hearing or even meeting, even though you could pick up the telephone in the old-fashioned way in order to resolve some issues quite quickly. But what's being said now is, are we going to see the end of documents-only arbitration? Because why only have documents only if in fact it's easy to organize a Zoom call where you can even have a quick oral argument? And what that raises, well, it raises quite a number of issues. But in international arbitration, in the kinds of cases that I've been handling on a documents-only basis, what I have found is that counsel outside of England, and particularly non-English speaking counsel, feel quite confident, it would appear, to write submissions. What they don't feel so confident in doing is speaking, let alone cross-examination. And so what I've wondered is whether the promotion of the idea that actually you could move away from documents only and you could have lawyers speaking in every single case, whether that wouldn't actually promote a particular kind of lawyer, particularly in London. We'd be talking about, the suave barristers. You'd be appointing them in every case, which is very opposite of what documents only arbitration was supposed to do.
Yeah, very interesting.
It's an interesting dilemma.
It's very interesting because it could have the reverse of an anti-diversifying effect.
Yes, exactly.
It's
exactly
the opposite
that,
of what you're
because,
aiming at.
Yes, yes. The great thing about documents only arbitration, where and these days, of course, it's extremely green because it's all by email. But what it means is that anyone, anywhere in the world, whatever time zone they're in, they don't have to wake up at 6 o'clock in the morning in order to participate in a call that's convenient to someone on the other side of the world. Wherever they are, they can participate in an international arbitration. I think that is really diversifying, inclusive, and engaging. And I think we should be worried about Zooming everywhere, because it might actually alienate people.
Presumably much less expensive also. I'm curious, I actually
Yes.
don't have any experience of documents only arbitration, and as a litigator, both domestically and internationally, it makes me very nervous, I have to say, not to be able to test the evidence of the other side. But can you help under what's the average size of the claim? What context do they arise in? Are they smaller cases?
Definitely small. So I deal with quite a few maritime cases where it's quite traditional for small claims to be arbitrated. And so they're quite often cases where the parties have actually been arguing for quite a long time over not a great deal of money. I mean, we're talking about tens of thousands rather than hundreds of thousands of dollars. The current limit for the small claims procedure under the London Maritime Arbitrators Association procedure, it is $100,000. I mean, that's the recommended limit. So small, but quite viable because the arbitrator's fee is fixed. The recoverability of costs is capped as well. But as I say, that there are cases in which the parties have been arguing, and quite often they turn on quite an interesting point of law, because they have disagreed on how quite often a standard clause or a variation on the standard clause should be interpreted. And in-house lawyers and lawyers with the insurers sometimes have already had a look at it. And then they decide, right, look, we just can't agree. And off it goes to arbitration in the traditional way. That is, they get a sole arbitrator who will be able to decide this for a fixed fee, which is viable for them. So it works quite well, but it's rough and ready. You're not going to get all the evidence that you would like. I mean, last week I had to make a decision on one extra point in a claim where the only evidence for a gangway being unsafe under the regulations of a port authority in a South American country, the only evidence I was given was one photograph. Now, there was no way that I could make a decision as to whether or not this gangway complied with local regulations or any international regulations, even without having the relevant one cited to me. But I had to decide whether or not the charterer was entitled to recovery of the hire of a safer looking gangway.
You raise a really interesting, bigger point about arbitration, James, which is, can we accept imperfection?
Sorry to interrupt, your audio is coming in very scrambled. Could you maybe try to turn off? It's coming in scrambled as if there's a voice scrambler. If you can try to still. Do you want to type in the chat and I will read what you say? I won't then. Okay. I was saying that there's an interesting question about imperfect dispute resolution. Yeah, for sure. Maybe Caroline, do you want to, I don't know if you have a view about this, step in, but I think it actually, and it jives with the issue I was raising before about what do you do about smaller cases and to control fees. Does that mean we don't get to have the Cadillac in every single case?
Oh, yeah, I mean, you know, I mean, I'm not a lawyer, so I can't really say, but, you know, it's just a matter of convincing the clients. And to me, I feel like in some ways, you know, if an imperfect solution is just going to lead to, you know, longer procedures, you know, in terms of, you know, having an award that you don't really like, and, you know, maybe you think there was some due process concerns there or something, and of course that's ground for annulling the awards, which is just going to lead to more complicated proceedings. So I mean, obviously, I mean, I guess the real question is, you know, where do we draw the line? You know, how much are we willing to, I don't want to say sacrifice because it's not exactly the right word, but to give up in exchange for getting some other benefit.
Is my voice better now?
No.
It might be a connection issue or something. You were fine before, so it spontaneously stopped working. I think we're coming up on our time shortly anyway. So any closing thoughts? Kieran, any closing thoughts I can read on your behalf from the chat? No, she's shaking her head no. Caroline?
Well, I just would like to say, I know we didn't really get to it, but there was a question posed about Section 1782,
yes,
which I've been following pretty closely for the last 2 years, I guess. And I have to say, I was so disappointed when I found out that the Sixth Circuit case wasn't going to the Supreme Court. No, the Fourth Circuit case, I mean. because this is, it's just a clear circuit split. You know, there just seems to be so much opinion on both sides of it, and it would just be a fascinating issue to go to the Supreme Court, and I hope eventually it does.
Anyone, any last closing thoughts from anyone? Hafiz, do you have any closing thoughts?
My closing thoughts will just be a word of thanks. So I'll let you, I'll let you go ahead, and then I'm happy to close after.
Well, wonderful. Well, thank you everyone for joining us, Caroline and Kieran, for your really insightful thoughts. James, thanks for jumping in. Really enjoyed the discussion, and thank everyone for participating.
Indeed.
Thank you.
Thank you very much. These are not, I mean, the conversation itself was very interesting, but it was also interesting given who was making these comments. These are not perspectives we often get to hear. And so to have them all together here was really interesting. So thank you.
Thanks for having us.
Thanks
Nice
so
to
much.
see you.
Have a good evening, everyone.
Have a good evening.
Thank you.
Goodbye.
Bye.